Hi, everybody. This is Bill Freivogel. I will begin by giving you my own history so you know why I can say what I'm saying. I graduated from law school exactly 50 years ago from the University of Illinois. I started practicing in Danville, Illinois. I was there for 3 years. For those of you in Chicago, Danville is about 130 miles south of here. I was there for 3 years. I did everything. I tried some cases. I drafted some wills. I handled a couple of divorces, things like that. It was really good preparation for coming to Chicago. I came here in 1968 as an associate with Ross and Hardy's. And what's kind of resonant about this is Ross and Hardy's then was in what was called the People's Gas Building, which was right next to your Chicago office. And more relevant is the fact that while we were in the People's Gas Building on Michigan Avenue, this building was being planned. Your Chicago office building was being planned, and it was going to be the People's Gas Building. But the chairman of People's chickened out. I forget why, but he decided not to make that commitment. So we stayed in that building for a good long time in the old building. So I was at Ross and Hardy's. I mainly tried cases. I didn't have a varied practice because that's just not the way large firms operated. But I did a lot of trial work over those years. I left the regular practice of law and joined ALAS, which is an insurance company that insures law firms for malpractice. I joined them in 1988, and my job was loss prevention, that is, work with the insured law firms to make sure they engaged in practices which were least apt to cause them to get sued. And what was interesting about that is when I went to work for ALAS, the guy in charge of loss prevention was Bob O'Malley, formerly a partner at Covington and Burling. Bob said, start reading the ethics rules, and he gave me a list of rules to read. I don't remember whether 4.2 is one of them, but that's one we're going to talk about today. But I wondered why he thought it was so important to read the rules, and I found out very quickly that adherence to the ethics rules is the first thing that a lawyer needs to do in order not to get sued. Now, there are lots of other things that could happen to you if you violate an ethics rule, and we'll talk about that in a moment. By the way, I left ALAS in 2000, and I was on my own advising law firms on ethics issues and risk management. There was a 4-year stint with Aon, which was a good opportunity to work with the large New York firms in the same capacity, that is, helping them with their risk management, loss prevention programs. All of this is involved now since 1988 in just a continuous being involved in the ethics rules. So that's my history. So why don't we move on? We're going to be talking mostly about Rule 4.2. That's the rule in Missouri and the rule in Illinois. California has an analog. I don't remember the rule number, but I know that these concepts are applied just the same in California as they are in other states. Just for your information, all states now have a version of the ABA model rules and are numbered the same as the ABA model rules. With the exception of California, they're trying to work towards some kind of coordination with the rest of the country. But I can tell you, based upon my work with California lawyers, that the rules are applied just about the same. Certainly the concepts we're going to talk about today are the same in California. So in terms of issue spotting, the California people in the audience just can take comfort in the fact that what we're talking about will apply to them as well. On this slide is a reference to a website, Freivogel on Conflicts, and you can get there. It's free. It's huge. You can get there by going to Google and just putting Freivogel in Google, and the first thing that comes up will be the website. It's devoted primarily to conflicts of interest, and there's a detailed table, alphabetical table of contents that you'll see devoted to conflict of interest type issues. But also, there's a reference at the bottom to a page called This and That. Actually, This and That is 3 pages, 1, 2, and 3. And that's This and That is where I put everything relating to ethics and loss prevention that aren't specifically conflict of interest type of issues. Page 2 of This and That, at the very top, is every case I have seen in the last 15 years, and that's how long that website's been up, relating to Rule 4.2 and communicating with represented parties is on that page at that place. They're not terribly well organized, but if you go down, you'll get the idea of the kind of tool that could be for you. Now, let's just talk about the basic rule. And the basic rule is this. Let's say you have lawyer A represents client A. You're in a dispute with client B. Client B is represented by lawyer B. And the issue is, can the lawyer for A go talk to client B without the permission of client B's lawyer, lawyer B? And the answer is no. You can't do it. Now, let's say that client B is an entity, like a corporation or an LLC or something of that nature. Then the rule says that basically that you can't talk to anyone in that entity without the permission of its lawyer who is high-ranking. Now, I use the term high-ranking. That's a little imprecise because as you go around the country, various states define that type of person like control group or something of that nature. And I'll leave that to you to know what state you're operating in. I know a number of you handle litigation in states other than Missouri, Illinois, or California. And this is one set of rules that you're going to have to know for the state in which the case is pending, because generally speaking, you'll be controlled by the ethics rules of the state in which a case is pending and which you're handling. So just be cautious of that. Let's talk about violating Rule 4.2 and rules relating to contacting represented parties. You can be disciplined for doing that, and there have been a number of cases, and there are some mentioned on my website. So that's one. Another is if you're in litigation and you approach or talk to somebody on the other side without the permission of their lawyer, you can be disqualified, and that happens. I've seen that come down the road a number of times. If you're admitted in another state pro hoc vice in order to handle a lawsuit in that state, violating their version of Rule 4.2, that is, talking to the other side without their lawyer's permission, can be grounds for revoking your pro hoc vice status. So that's something to be careful of. And again, that's where when you're venturing beyond your own state, you better find out what that state's version, the other state's version is of this rule or of these concepts. If you gather evidence in the course of violating Rule 4.2, the court can order that evidence not used or quash it, in effect. If you send somebody in violation of Rule 4.2, you don't do it yourself, but you send somebody else to do it, and you have control over what they do, they may not be able to testify as what they discover if they've been violating the rule. And in extreme cases, your pleadings can be stricken. That is, in effect, you can be defaulted or your case can be dismissed because you've so tainted the proceeding by your insensitivity to that rule. And there was a recent case, and it's on my website, where a settlement of a case was voided or invalidated by the court when the court was informed that one of the parties had violated Rule 4.2. here's kind of an interesting take on the rule. This is a case, the site is up there, the Lexus site, Best Deals on TV versus Navid. What had happened was a number of employees had left, I think Best Deals was the plaintiff, had left Best Deals to either go to work for a competitor or to form their own competing company. And so the former employer sued these employees, including fraud-type counts, RICO, and so forth. And what they did, this was all carefully orchestrated. Within minutes after filing the complaint, the lawyers for the plaintiff went after the defendants, cornered them, and interviewed them, and asked them questions and so forth. And I think even one of them said, "Hey, we didn't even know about this. We haven't had a chance to hire lawyers yet, and so you shouldn't be doing this." Well, in any event, they did gather some information from some of the defendants before they were able to hire lawyers. And once they hired lawyers, the lawyers, of course, immediately figured out what had happened and moved to disqualify the plaintiff's firm. I have up there as a question, what was the ruling? In fact, this district judge said that under California's version of 4.2, that rule only applies to represented parties, and these guys were not represented at the time that they were being interviewed by the plaintiff's lawyers. I think that's kind of a one-off thing, and I wouldn't recommend that you adopt that strategy if you're going to file a lawsuit against somebody, but I thought it was interesting nonetheless. And then, of course, I immediately thought when they said, "Hey, you can't talk to us," the plaintiff's lawyer said, "Well, you ain't got no stinking lawyers," which is a play on the words, "We don't need no stinking badges," which was in that movie, The Treasure of Sierra Madre. But in any event, I thought that was an interesting. We know that lawyer A can't take the initiative to go talk to client B. Okay, what if client B calls lawyer A and says, "Let's talk about the case"? And the answer is the lawyer can't do that, should not do that. Doing so would be a violation of Rule 4.2. Now, one issue has come up in this kind of situation. What if client B is highly sophisticated, maybe even a former lawyer? We'll talk about that in a moment if we have time. And there have been a few cases where the court has cut some slack where the client on the other side, who was highly sophisticated, did contact the lawyer, but no harm was done. The court didn't do anything to the lawyer. But here's a variation of that. Let's say you're handling a divorce. You're representing the husband, and you're in your office, and you get a call from the receptionist, and she says, "Sir, there is a young lady out in the reception area. She claims that she's the wife involved in a divorce that you're handling." And, of course, you're representing the husband, and so you venture out into the waiting area just to politely inform the lady that you can't talk to her because she's the party on the other side, and that you've got this 4.2 rule obligation. And she said, "No, that doesn't apply here because I just fired my lawyer. I don't have a lawyer." And so then the issue is, can you take her into your office, sit down, and have a long chat about the divorce case and that sort of thing? And that's what a lawyer did in one of the cases. And there was later a motion to disqualify the lawyer, and the court granted the motion because the lawyer should have, according to the court, the lawyer should have picked up the phone and called the wife's lawyer or former lawyer, whatever it was, and said, "Look, have you really been terminated?" And of course, if that guy says, "Well, no, I mean, she's not talked to me about firing me or anything of that nature," well, then you got to stop. And that's what the court said the lawyer should have done in this particular case. Do we have a question? Okay, we got a question. I have help here. Carol Vosecki from in the Chicago office has kindly agreed to do this. Says, what if the client represented by outside counsel in the case is the general counsel of the company? that I was going to talk about that later, but I'll talk about it now, and that is if the person that you want to talk to is an inside lawyer, in-house counsel for the other side, but the other side is being represented by an outside firm. The issue is, can you talk to in-house counsel? Traditionally, historically, the answer was no, but that has softened quite considerably, and as we'll mention in a minute, there have now been some ethics opinions and so forth that say you can talk to an in-house counsel without the permission of the outside lawyer. And the reason is that the purpose of the rule 4.2 is to keep lawyers from overreaching. That is, going to lay people out there and browbeating them and trying to mislead them into saying they have a bad case or something of that nature. And of course, if it's a non-lawyer, that person has no way of knowing exactly what is going on in terms of the significance to the lawsuit or to the whatever the legal matter is. So courts and ethics committees generally have softened on the approach to in-house lawyers talking to them. Suppose you want to write a letter to the opposing lawyer, but for whatever reason you think it would be a cool idea to copy the client, the other party. And traditionally the rule has been, and I'm not aware of any change in this rule, that you cannot do that. That's a violation of Rule 4.2. Let's talk about where the other party is an entity. And the question is, who at the other party can you talk to? Is every employee a client of the other side for purposes of enforcing Rule 4.2? And the answer is no. And there are different approaches depending upon whether it's a current employee or a former employee. Generally speaking, a lawyer may talk to employees of the other side. If they are current employees, the lawyer can talk to them if they're not high-ranking. Now, again, what is high-ranking? And that's where the states vary as to how they define somebody, either in the control group or something of that nature, like the president, the chairman of the board, and so forth. So they're all off limits. And if you're going to embark on a campaign to talk to former employees of the other side, you better know where you are in the state, the rules of the state in which the case is pending, because that's going to be the key. Now let's move to former employees. There's a subtle difference. Well, it's not very subtle, actually. You can talk to any former employee, regardless of rank, when the person was an employee, was an employee. Now, as to talking to the people you're allowed to talk to, both current employees and former employees, the attorney-client privilege plays a role. And by that I mean, if that particular employee had been privy to attorney-client communications while working for the company, that is, sat in on meetings with the company lawyer and so forth, where this matter was discussed, you may not inquire in interviewing a current or former employee. You may not inquire about those conversations. And I'm trying to think of an example of that. I can't right now, but I know what it was. It was a lawyer had approached an employee of the other side and had the presence of mind to give that employee a written instruction. Look, we're going to talk about the case and the facts of this case, but do not reveal to me anything you know involving anything having to do with communications with your employer's lawyers. And the court said, where there was a motion to disqualify the lawyer, the courts denied the motion, saying handing that employee, current or former employee, that writing was a very influential thing in terms of what the court decided. Now, there was a recent case, and this is on my website, where a lawyer talked to an insurance adjuster for the insurer of the other side. And the court said that that was perfectly okay. That the adjuster was not in the category of somebody who can't be approached. Now there was a case in Pennsylvania. It was my favorite federal judge, Jean Pratter, went before her, and there a lawyer he was suing a hotel, and the lawyer managed to get to the secretary of the president of the hotel company and talked to her and got her to cooperate in certain ways. And Judge Pratter disqualified that lawyer and was highly critical of that particular conduct. I read the opinion, and it didn't sound just right to me, and I sort of forgot about it because, she was, after all, a low-level person, a secretary or an assistant or a clerk or something of that nature. And I thought, that's coming down awfully hard without at least explaining why this person would be within the category that you can't talk to. And it went up to the Third Circuit, and they reversed Judge Pratter and said that basically on those grounds that she was too harsh to that lawyer. So I don't know what you do with that, but there you have it. Here's another one. And I've seen it come up in several different contexts. I was attending a seminar, and I won't say where because this involves the former U.S. attorney at that place. But he was now in a law firm, and he was the seminar had to do with healthcare fraud, and there's been a huge enforcement campaign going on among U.S. attorneys and the federal agency that deals with healthcare, and in terms of kickbacks and overpayments and that sort of thing. And the issue was, what do you do if you're representing a hospital company, and you know that this enforcement campaign is going on, and you want to protect against maybe having a search warrant served and enforced on your client. And, of course, there you get into the very sensitive area of what can you tell the employees to do or not do in the case there is a search warrant served. And I'm not sure whether the rules are uniform on this or not, but I know it's a delicate issue. And so this former U.S. attorney was speaking to this crowd, and he said, well, what we do is when we think that something like this is in the works, we'll inform the United States attorney that my law firm, represents every employee and officer of healthcare company X, Y, and Z. Therefore, they won't be able to talk to the government, and the FBI won't be able to talk to any employee if they're executing a search warrant. And I asked the question myself because I said, well, now wait a minute. Where you suspect that there might be an issue with the U.S. attorney or the agencies involved with healthcare fraud, don't you do internal investigations? Doesn't the hospital company do an internal investigation? And when you do an internal investigation, you talk to the employees, right? And what do you tell the employees? You tell them you do not represent them. You tell them that anything that you learn from them, this is I forget what they call it, the warning that anything you say, we can tell the management about it, and so therefore we don't represent you. Well, how is that consistent with telling the U.S. attorney that you represent all the employees? And he didn't have a ready answer for that. So the other is there have been a couple of cases where one in particular was a class action where the defense, the company, the law firm representing the defendant company in this class action, and the class action involved claims. There were two classes in the case. One involved high-level employees, supervisory employees, and the other involved lower-level employees. And the law firm for the defendant said you can't talk to any of them because we represent them all. And the court said that was improper, and I don't remember what the whether they disqualified the law firm or what. But in any event, the whole point of that is don't think you're going to be buying a lot of peace and avoiding a lot of problems by claiming to represent all of the employees of your client corporation or LLC or whatever, partnership or whatever it is, because there could be very serious problems with that. Okay, we talked earlier about in-house lawyers. Now the wisdom is, and the opinions are consistent with the concept that in-house lawyers are now approachable. You can call them up. You don't need to call the outside lawyer and get his or her permission. And you can copy in-house lawyers with communications with outside counsel, and you can even write to the in-house lawyer without the permission of outside counsel. Let's talk a little bit, I'll give you a little history. I mentioned I graduated from law school in 1965. At that time, the wisdom was, and this was in Illinois, which hadn't even adopted the older ABA model code yet. The wisdom was that not only can you not talk to the other side, you can't even know that your client's talking to the other side. There's always been an understanding that the plaintiff and defendant in a lawsuit can always talk to each other. That's always been true. But can one of their lawyers know about it even? And back then, when I started practicing, that was a no-no. If you knew that your client was talking to the other client, you had to tell them to stop. That's where things started. Later on, it was okay if you knew the clients were communicating. There was nothing particularly wrong with a lawyer knowing about that. And then later, even later, and then we're going over years now, it became okay to suggest to your client that it's okay to talk to the other client if there's a purpose involved. For example, if you as a lawyer, something in the water tells you that your offers to the other side are not being conveyed to the other party, you can, and this has been approved by in most places I'm aware of, you can say to your client, look, go talk to the other party and just ask if he's learned of our offers. We offered $100,000 to his lawyer to settle this case. Does he know about it? So that's been okay for a good long time. Again, if you're going to do anything like this, you better know where you are under the rules of the court where the case is pending, but or in the state. Then it kind of became tacitly okay to even kind of script what your client might say to the other client. And then in 2011, the ABA Ethics Committee came out with an opinion, which is cited on this slide, 11-461, which went way beyond and said, you can even draft a settlement agreement, give it to your client, and tell your client to go to the other party without permission of the other party's lawyer and get them to sign the settlement agreement. And that was, in my world, people that do what I do were very critical of that opinion. That just went too far. And in a couple of states which have addressed it have said nothing doing. I read a statement by the Minnesota Bar Council who said, look, we love ABA ethics opinions. They're not binding on anyone, but they're highly authoritative, and they will, in almost every case, furnish you with a safe harbor. A Minnesota lawyer who's acting consistently with the ABA ethics committee will not be prosecuted, or at least not readily. But that's not the case with Rule 4.2 and this opinion by the ABA Ethics Committee. We will not allow that conduct, so don't even think that you can arm your client with a settlement agreement and have him or her take it to the other side and try to get a signature without the other side's permission, the other side's lawyer's permission. Do we have a question? I'm going to read this and try to understand it as I read it. Do all these restrictions apply only to litigation or also to the negotiation of transactions? For example, an in-house attorney is working with her business person to negotiate a sale or sale contract or lease with a potential seller, buyer, or now I can't see. Just a minute here. Okay, with a potential seller, buyer, or tenant who is represented by counsel, either in-house or not. As a practical matter, all of the business people are sending emails back and forth discussing the terms of the deal, copying both attorneys. Does the attorney have to respond only to the other attorney, or can she include the clients on the emails? That is a very good question. That was sort of going to be covered a little later on, but let's talk about it right now. Certainly the issue is not nearly as difficult when you're not talking about litigation. When you're talking about doing a deal, there's a lot of that going on where you may bump into the CFO of the other side just at a benefit dinner or something like that, and it's very tempting to say, boy, you guys are sure driving a hard bargain on issue X or Y or whatever, and I think a lot of that happens and nobody gets very excited about it. It's where you get excited about it is where you're dealing with unsophisticated people who can't protect themselves, people who don't understand what's going on, and so forth. I'll give you an example of a situation. A friend of mine, a colleague, former colleague, gave this example. There's a conference call, and there are three parties to this potential transaction, and they're all on the CFOs and so forth, presidents, and their lawyers are all in on this conference call, and you're going through, deal points. Right at some stage, one of the lawyers says, look, I've had this long scheduled meeting. It's coming up. I've got to leave this conversation. We haven't agreed on when to have the next conversation. So let's, you guys agree on a time and date for the next negotiating session. And he clicks off. That leaves his client, who is happens to be the CFO of his client company, and the CFO says, "Hey, we've only got one deal point left to talk about. I'm prepared to talk about it right now." And then, of course, one of the other lawyers says, "Look, we really shouldn't be doing that because your lawyer's not here," and he never gave consent to talk about the deal itself, just the date for the next meeting. And then the CFO says, I went to Harvard Law School. I was a partner at Sullivan and Cromwell. I did these deals hundreds of times. I know more about them than my lawyer knows about them. Let's talk about the thing, the last deal point. And the question is, can you do that? And the answer is technically no. But if it's almost the chances of anybody claiming there was overreaching or improper conduct or something of that, even though there was a technical violation of Rule 4.2, but it's kind of an interesting variation on that question. We're going to change slides now. Let's talk about some of the ethics rules that are involved here. 4.1 is the rule that says you may never lie to anybody. You may never lie to your client. You may never lie to the other side. You may never lie to third parties, and so forth. 4.3 is the rule that deals with how you talk to a person, not a client, but say an employee of the other side or anybody else who's not represented. Of course, 4.2 talks about talking to represented parties. 4.3 lays down some rules about what you can say to an unrepresented party, and basically you have to be truthful with them, and you have to tell them where you're coming from and what you're in, if you're interested. That is, you represent a party in a case, and that's the capacity in which you want to talk to this person, you've got to say something like that. Then there's Rule 8.4c. That's sort of a catch-all, and it says that a lawyer may not engage in dishonesty, fraud, deceit, or misrepresentation, and that can kick in on just about any time. Anytime there's a sense that the lawyer has crossed the line, you might well resort to that particular rule. And then Rule 5.3 is the duty to supervise non-lawyers. That is, if somebody on your staff has occasion to talk to somebody else in the case, you've got to tell them what the rule is so that they don't do what you can't do under Rule 4.2. Social media, in terms of 4.2, I'll explain why I'm not part of any social medium now. Friending is, I know that's what you do in Facebook, and that's a way of becoming more intimate with some other person on Facebook. And the wisdom is, there have been cases on it, there have been ethics opinions on it, that you may not friend or ask to be on your network or whatever else, or be a private type person, the other side, or an employee of the other side, one of the off-limit employees, I should say. I don't know what about a low-level employee, whether it's okay to friend them or not, but certainly not the people that are normally off-limits will be off-limits on social media. Certainly, it's okay to check out anybody's site in social media in order to, because it's public information, or at least whatever is public, you can check out that, and that's perfectly okay. It's just like looking at them up in the phone book or something. So that's about all I can think of in terms of social media. Let me tell you why I'm not part of it. And younger people are going to think I'm nuts, but I yield to nobody in technology, nobody on technology, because I've had my own website now for 15 years. I regularly use email, and I use a lot of other tech type things. But one thing I learned about social media, I'm talking about now about primarily Facebook, Twitter, and LinkedIn, is they have this private versus public dichotomy in each case, and I cannot for the life of me figure out when really something is public versus private. And I defy anybody, and I don't care how young and tech savvy you are, to know exactly when you're being public and when you're being private. And for a lawyer, in my opinion, that's deadly. At least for me. Now, to each his own, I suppose. But the last thing, and so I resigned from all three of them several years ago. The last thing I need, if I'm counseling with a major law firm and their general counsel gets a friend request from me, which I don't even know about, he's going to say, what the hell else have I been disclosing? And the other thing is, you don't know when the social medium has actually talked you out of your contact list and all of your contact information. And that can be deadly, because all of a sudden now you're put in a position of revealing who your clients are. And most people think that under Rule 1.6 you may not reveal who your clients are. So that's my take on social media. Okay, this relates to 4.2 relates to pretexting, and by pretexting I'm referring primarily in housing discrimination cases where you send out a couple to try to rent an apartment, and the landlord says, well, we're full, we don't have anything to rent. You say that's an African American couple, and then you send out a Caucasian couple, and they say, oh, sure, we've got 6 apartments, what kind do you want? That sort of thing. And then trademark lawyers, IP lawyers, get involved in this kind of activity. A good friend of mine is a leading trademark lawyer, Bob Sakoff, at the Pratter firm in Chicago. has written a paper called Ethics of Deception, and he's updated. It's not long, but boy, it really pulls together all the authorities, some of which I'll talk about in a moment, in a very clear, nice way. And I have Bob's permission to share that with you, and you're welcome to contact Bob at his firm in Chicago. He won't be hard to find in Google and so forth, and ask for a copy, and he said he would provide one to anybody asking. A couple of cases worth mentioning: the Midwest Motorsports case, which is cited. There, a lawyer sent a former FBI agent to sort of investigate this retail establishment undercover, and Midwest Motorsports, and the guy crossed the line in two different ways. The investigator, first of all, he recorded his conversations with personnel at this business place without their knowing it, which is a violation of some states' laws and perhaps not others. But the second thing was the owner came out of the business, and of course under Rule 4.2, this guy is off limits. And nevertheless, the investigator talked to the owner and recorded the conversation, and came back to the lawyer with all of this. There was a motion to quash all of the evidence that the investigator gathered, and also to disqualify the lawyer who sent the investigator for crossing the line on Rule 4.2. And the court granted the motion to quash the evidence. That is, nothing that this investigator had gathered could be used. But the court did not disqualify the lawyer who sent the investigator, because the court found that the lawyer really didn't learn anything. Next, I cite a New York County Law Association opinion, ethics opinion, number 737, and there, that opinion lays out in a way that you don't see very often, very clearly, when a lawyer involved in this kind of activity, trying to find out about housing discrimination, trying to find out about trademark infringement, what the lawyer can and cannot do, or what the lawyer can and cannot allow his people to do. And the opinion uses the term dissemble. I've heard that term over the years, and kind of felt I knew what it meant, but really what it means is you can be a little bit dishonest in the course of these kinds of investigations, particularly where you're trying to discover misconduct. The last one I mentioned on this slide is a hoot. It's involving a lawyer disciplinary case. The lawyer's name was Hurley in Wisconsin, and what the lawyer had done, the lawyer was representing the defendant in a child molestation case. The defendant had evidently behaved inappropriately with a young boy. And while this prosecution was pending, the lawyer sent an investigator with a story and a deal. He had the investigator go to the boy, and he said, by the way, don't do this unless the mother's there. Go to this boy where he lives and tell him you're with a computer company, you're doing a survey, and if the boy will allow him to have the boy's computer, the investigator will give the boy a new computer. And so the boy, in front of his mother, turned over his computer and gave it to the investigator. The investigator gave the boy a new computer, new laptop, I guess. And, of course, later, when it all hit the fan, one of the things they discovered when they got a hold of the boy's computer is that they were able to show that the boy was really the initiator of whatever went on. He kind of forced himself onto this poor defendant. I don't know how that works, but in any event, they were able to avoid, I guess, the prosecution, or at least win the prosecution. But a complaint was brought against the lawyer by whatever the bar prosecutor is in Wisconsin, went all the way to the Wisconsin Supreme Court, and they said what the lawyer did was okay. That prosecutors engage in this kind of conduct all the time, and therefore what's fair for the goose is fair for the gander, I guess, and it was okay for this lawyer to send the investigator, misrepresent who he was, get a hold of the kid's computer, and so forth. Don't rely on that. It would be my advice, but in any event, that's it for pretexting. Can you change the slide now? Okay, before we get into opening it for questions, it's open for questions now, obviously. Do we have any more questions? No, we've answered the ones that have been asked. There's a related set of cases to 4.2 and communicating with represented parties, and that has the concept is called having what you shouldn't, and that is a lawyer who finds out that he or she is in possession of a document or some other piece of evidence about the other side that's really going to crush the other side in the case. And it could be something the other side said or wrote or a document the other side created. And the issue is, how did the lawyer get hold of this incriminating information? There is in many of us, and I certainly have been involved in lawsuits where one side accidentally or inadvertently produced, say, privileged documents to the other side. That the staff who was supposed to have gone through this stuff hadn't been careful, and they allowed some privileged stuff to pass. And now the law is being refined as to inadvertent production and things of that nature, or inadvertent transfer of any kind of information. And that's taken, in addition to court rules, federal rules of civil procedure and similar state rules. That's sort of covered now. There's sort of a clawback provision in most places now that if something's been accidentally produced or discovered, that if they give it back, they're okay, and the other side, the person who inadvertently produced it, is entitled to having it back. But then there are variations on that, and there's a relatively new ethics rule, Model Rule 4.4b. I think most states have adopted it, but many have not. It doesn't really change much, but in states that have adopted 4.4b, it makes clear what your obligation is if you receive something from the other side inadvertently. Your only obligation under the rule is to notify the other side. The rule doesn't say whether you have to return it, whether you can use it or not, and so forth. It sort of leaves it up to the rules of the jurisdiction or the court rules as to whether or not you can use that stuff. There's a case out of Western District of Washington, Richards versus Jain, Jain. It's 168 F Sup 2nd 1195. This is not on your slides, but that is the site. And if you feel free to follow up and ask me for the case, I can give it to you again. But any case, Richards versus Jain involved an employee who was suing his former employer for, I forget what it was, employment-related type of thing. And before he left the employer, the employee managed to download or put on a CD several thousand email messages. And he took that to his lawyer, the plaintiff's lawyer, and gave it to the plaintiff's lawyer. The plaintiff's lawyer never looked at the CD. He gave it to an assistant or paralegal and asked the paralegal to go through the messages and categorize them, irrelevant or not relevant. I forget whether he asked them to also categorize them as to whether or not they were attorney-client communications. But in any event, there were hundreds of attorney-client communications that this particular employee had been privy to, that is, communications between the employer and the employer's lawyers. And there was a motion to disqualify the plaintiff. Once the other side, the company, discovered this, they made a motion to disqualify the plaintiff's lawyer for having done that, for receiving, in effect, the CD. And the district judge did disqualify the lawyer, even though the lawyer himself had not looked at the messages. But the judge just said, no, he had them like for 6 months or a year. And the judge, that's just too long to trust that nothing untoward occurred. So that's that. That case has been followed a couple of times. If you go to my website, on this and that part 2, and you scroll down to just do a word search on that page for Jain, Jain, you'll find that and about 6 or 8 other cases involving similar kinds of events where a court either did or did not disqualify a lawyer, where the court quashed evidence of that nature. This is related to 4.2 because we're really talking about a lawyer coming into information inappropriately, just as talking to the other side would be. One other case I'll mention before just leaving it for questions is a case called Merits Incentives. It's in the Nevada Supreme Court. I'll give you the Lexus site. It's 2011 Nevada Lexus 78. There, a lawyer in litigation received in the mail in an unaddressed, in an envelope that didn't have a return address on it, a CD. And that CD contained lots of documents relating to the other side, including documents that could only have been obtained from the other side, some of which should have been privileged and so forth. So, in any event, the lawyer did not pick up the phone and call the other side. The lawyer didn't know where this had come from. Certainly the lawyer didn't cause it to happen. He just got it in the mail and it was unmarked. So what did the lawyer do? What the lawyer did was, in complying with discovery, either document requests or interrogatories or whatever, the lawyer answered the discovery referring to the documents that were on the CD that the lawyer had received. So in effect, the lawyer was saying, here it is, here's what I got. Now the lawyer didn't flag it and say, here's what I got from a mysterious source. He just says, I've got it, here it is. And ultimately, well, there was a motion to disqualify the lawyer when the other side figured out what had happened. And the Nevada Supreme Court, I forget what the lower court did, but the Supreme Court at the end of the day said the lawyer basically complied with his obligations by disclosing the documents that he had received in discovery responses. The court noted that this was obviously not inadvertent, that whoever sent this stuff to the lawyer intended to do it. So it didn't fall within the letter of Rule 4.4b. But the court said that we're not going to worry about that because the lawyer really did, at the end of the day, what he should have done by disclosing that he had it. So on that note, thank you very much. And my contact information, so that's how you get a hold of me. So thank you very much.